Tonight, we now know that the initial vote among the jurors in the George Zimmerman trial, according to juror B37, was 3 not guilty votes, 2 votes for manslaughter, and 1 vote for second-degree murder.
A verdict has been reached in the murder trial of George Zimmerman.
We, the jury, find George Zimmerman not guilty.
Justice for Trayvon! Not one more!
There are going to be 100 demonstrations.
Demonstrations are planned in more than 100 cities nationwide.
Mr. Zimmerman was found not guilty beyond a reasonable doubt. He was not found innocent.
The verdict is not guilty.
We proved George Zimmerman was not guilty.
George Zimmerman was never guilty of anything.
But that doesn't necessarily mean innocent.
It was a self-defense case.
You got a 17-year-old kid who was minding his own business.
Trayvon Martin did nothing.
There was a young man walking in his neighborhood unarmed.
Trayvon Martin was profiled.
Someone decided that he looked suspicious.
There is no doubt that he was profiled to be a criminal.
The defense's narrative was essentially racial profiling is okay.
Just his existence was almost illegal.
Trayvon Martin did, in fact, cause his own death.
Trayvon Martin is dead.
Trayvon Martin did, in fact, cause his own death.
What I could see of the trial, they put him on trial.
This case is not about race.
It has nothing to do with civil rights.
Part of how we know that this is about race is by the differential racial experiences that people are having.
We have opened an investigation into this matter.
The important thing is that they do the investigation.
We must not forego this opportunity to make better this nation that we cherish.
Two days after George Zimmerman was found not guilty of the second-degree murder or manslaughter of 17-year-old Trayvon Martin, U.S. Attorney General Eric Holder said today that the Justice Department is still investigating whether it should file federal criminal charges against George Zimmerman.
We are also mindful of the pain felt by our nation surrounding the tragic, unnecessary shooting death of Trayvon Martin in Sanford, Florida last year. The Justice Department shares your concern. I share your concern. Moreover, I want to assure you that the department will continue to act in a manner that is consistent with the facts and the law.
Tonight, the jurors who reached the verdict in the George Zimmerman case remain anonymous, but one who is looking for a book deal, juror B37, along with her attorney husband, has signed with the Martin Literary Management in hopes of writing a book to explain why she believes, quote, the jurors had no option but to find Zimmerman not guilty due to the manner in which he was charged and the content of the jury instructions. Former Florida State Senator Dan Gelber argues that the Stand Your Ground law made it harder for the jury to convict George Zimmerman. Gelber writes, when the legislature passed the Stand Your Ground law, it changed the rules of engagement. It eliminated the duty to avoid the danger, and it eliminated any duty to retreat. Here is the actual jury instruction read to Florida juries prior to the legislature's enactment of Stand Your Ground. The defendant cannot justify the use of force likely to cause death or great bodily harm unless he used every reasonable means within his power and consistent with his own safety to avoid the danger before resorting to that force. The fact that the defendant was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if by retreating he could have avoided the need to use that force. And here are the instructions the George Zimmerman jury received.
If George Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony.
Joining me now, MSNBC contributor Joy Reid and MSNBC legal analyst Zachary Carter. Joy Reid, there you have it. We have one of the juror who is speaking tonight saying that the jury instructions, in her view, pretty much locked them in to a not guilty verdict. And when you read the difference in the charges to the jury, the instructions to the jury, before stand your ground and after stand your ground, it does seem as though we have changed the dynamics of every self-defense case in Florida with the stand your ground law.
Yeah, absolutely. And I spoke with Dan Gelber today, Lawrence, and he was talking about the fact that, first of all, it passed the state Senate unanimously at the time he was in the House, and that he argued at the time that the problem with changing those instructions is that essentially you encourage somebody who's inclined to be uncivil or do something overly aggressive or do something stupid not to have that sense of restraint. Because what you've now said is you don't even have to avoid getting into a situation that could result in you using deadly force. Meaning that for George Zimmerman, had the old instructions been in place, just following Trayvon Martin and not fleeing from the situation, if he realized, wait a minute, Trayvon Martin's not going to just let me talk to him, that would have been a completely different instruction. It would have opened the door to a manslaughter conviction. But what's happening in Florida is that you've had ALEC and the NRA pushing and pushing and pushing the boundaries to indemnify gun owners by saying you can carry your gun in more places and you can use it. You can discharge your firearm and be indemnified from criminal or civil prosecution because of it.
Zachary Carter, you're a former federal prosecutor. What is your sense of what's possible? We heard what Eric Holder said today about the Justice Department looking at this. What do you think is possible?
What's possible is a prosecution under federal civil rights laws for a homicide committed because of the race of the victim. Now, that's always a challenge because it is difficult, and always has been difficult in this country, to persuade jurors that an act has occurred because of racial animus. But there was a civil rights leader from the 60s who was fond of saying that America, when it comes to issues of race, lives in the 51st state, the state of denial. And that's something that prosecutors confront when they have cases where race is a core and important issue, as it was in the state prosecution.
And Joy Reid, the stand your ground law is also being cited by some today as a reason why there may not be a civil lawsuit brought in Florida, because the stand your ground law has an impact on the thresholds that you have to meet in a civil case like this.
Yeah, it does change the thresholds. Now, it isn't correct that there couldn't be a civil case, because had George Zimmerman actually called for a stand your ground pre-hearing before the actual trial in chief begun and had won that hearing, he would have not only been excused from prosecution, it would have actually prevented the Martin family from filing a civil suit. But that is not prevented. It's just that the barrier that you have to meet is very high, but still lower than it is in the criminal case. Regardless of that statute, the burden that has to be met in that civil trial is still lower than the prosecution's burden in this case.
And Zachary Carter, going to what we've learned tonight from the juror who is speaking, she basically recited the defense's case almost word for word, almost element for element, including she said she has absolutely no doubt that that was George Zimmerman's voice screaming on the 911 tape that we all heard. And I'm not sure how that jury could have reached that conclusion with absolutely no doubt on who was screaming on that.
Well, the explanation that she gives, according to the transcript of her statement, is kind of a bootstrapping argument. She believed it was George Zimmerman's voice because of George Zimmerman's injuries. And for that reason alone, she tends to believe it must have been him screaming because he was injured. And that obviously is not necessarily the case. It could have been the case that when confronted with a loaded firearm or at any point during the struggle, that Trayvon Martin could have been screaming because he was in fear for his life. And that's a lot more consistent with the ultimate result.
And Joy, we are learning from that one juror. We may hear from others, but so far it's just one. That she was in favor of not guilty right from the start, but that there was real movement in the jury. There were 2 votes in the first round for manslaughter, and even 1 vote for second-degree murder.
Yeah, and there is a lot of theory that goes on about groupthink, and it's one of the reasons that a lot of people are critical of Florida's want of having 6 people on a jury instead of 12. It's very difficult to withstand the pressure of a majority. If you were 2 or 1 that are saying that you want a guilty verdict, then you have a majority of people who are saying they want not guilty. And especially since you're sequestered, there's a lot of time pressure. I mean, look how late they went into the night. You've got to imagine that some of the jurors who wanted a guilty verdict were being really pressured to get out of there to finish it. And by the way, I think it is relevant to point out that one of the failures of the prosecution was to keep this juror off the panel. This juror, B37, is the one who in her voir dire said that she felt that the mass protests calling for the arrest of George Zimmerman were riots, and she still got on this jury. So I can't imagine that she came into it without at least some predisposition toward the defense.
Well, and jurors like that used to be actually thrown off by the judge. You wouldn't even have to use up one of your challenges on that. But Zachary Carter, as we've moved more and more throughout the country toward having everyone serve, we have kind of broadened the definition of what we think is a neutral juror.
Well, there appears to have been a gross insensitivity to the realities of race in American society and its role in this case. An insensitivity on the part of the prosecution in avoiding any mention of race like the plague, an insensitivity on the part of the judge who actually prohibited the use of the term race, even though in some schizophrenic way admitted the use of the term profiling. I mean, profiling without race in this case is like coffee without caffeine. I mean, what's the point?
Yeah, and Joy, we heard from the juror that she said she did not believe that Trayvon Martin was profiled because of race. She said that at one moment, and then at another moment she says, well, you know, the previous crime in the neighborhood was committed by black suspects, so the following made sense to her.
Yeah, and I mean, she profiled him in her interview with CNN. Yes. She's saying, well, you know, he was cutting through the back, and anybody who's seeing somebody walking around like that in the dark, well, I mean, who wouldn't think they were suspicious? I mean, it's extraordinary to me that you could have such blatant sort of cultural misunderstanding, blatant profiling after the fact by this juror, but saying, you know, we didn't think it was racial. He just happened to be one of those suspicious black teens.
It also appeared that the prosecutors missed an opportunity through facts readily available to them to demonstrate 2 parallel scenarios in this case. One that demonstrates how Trayvon Martin should have been treated, and the other that demonstrates tragically how he was treated by George Zimmerman. There was a store surveillance tape that showed Trayvon Martin entering a convenience store to buy the infamous Skittles and iced tea. He was dressed the same way he was when he was confronted by George Zimmerman. And yet, that occurrence was uneventful. The store clerk wasn't alarmed by the presence of Trayvon Martin and his hoodie. The store clerk, when Trayvon Martin presented the Skittles and the iced tea and placed them on the counter, didn't back up in alarm when Trayvon Martin reached into his pocket to take out the money to pay for them. I mean, you can only wonder what would have occurred if George Zimmerman had been the store clerk. I mean, that's the kind of information, the kind of evidence that's irrefutable, that you can use as a vehicle to tell a story of contrast between how Trayvon Martin was viewed by this store clerk, not as a potential criminal, not as a thug, but as a customer, and how he was treated by George Zimmerman.
Former U.S. Attorney Zachary Carter, thank you very much for joining us tonight. Joy Reid, I'm going to need you to hang around for the next segment. Coming up, more on what this verdict says to America, about America, and Nate Silver's new prediction on the future of the United States Senate and therefore the future of the Democratic Party, and the latest maneuvering on Washington's favorite form of socialism, including Republicans' favorite form of socialism.